discuss about the valid marriage. As we already know that there are 5 essential conditions for a valid marriage: monogamy, mental issue, age, prohibited relationship, Sapinda relationship. The first point we have already discussed: monogamy. Monogamy means neither party is spouse living at the time of marriage. Now clause 2. Now today we will discuss about the clause 2 onwards. Clause 2 is regarding the mental health. As per this clause, 3 conditions must be fulfilled at the time of marriage. The first one is, at the time of marriage, neither party is incapable of giving valid consent. The second is, neither party should be suffering from a mental disorder at the time of marriage. The third point is, no person has been suffering from the attack of insanity. As per the clause, section 5, clause 2, subclause A requires that at the time of marriage, neither party is incapable of giving a valid consent to marriage due to unsoundness of mind. Clause B, according to subclause B, the mental disorder means neither party to marriage should be suffering from a mental disorder of such nature. Clause C, recurrent attack of insanity means the person has been subject to recurrent attack of insanity. He is also not qualified for marriage under Hindu Marriage Act. If a party to a marriage is not suffering from any mental defect described under section 5 clause 3 but fails ill mentally after the marriage, there is no violation of this condition. In the case of Shrimati Alka Sharma versus Abhinash Chandra Sharma, AIR 1991, MP 205, in this case, the High Court of Madhya Pradesh held that the court can nullify the marriage if either condition or both conditions are fulfilled due to mental disorder of party. Now we will come to the clause 3. Clause 3 is regarding the age. According to this clause, at the time of marriage, the bride must have completed the age of 18 years and the bridegroom of 21 years. Thus, a child marriage is prohibited under the Hindu Marriage Act. However, the violation of this condition doesn't make the marriage void or voidable. It means that it is valid, though it may attract penalties. But it can become a valid ground for repudiation of the marriage. According to section 18 of Hindu Marriage Act, anyone who procure a marriage for himself or herself in contravention of this clause, this subclause, may be punished with up to 15 days imprisonment or with a fine up to ₹1,000 or with both. The Prohibition of Child Marriage Act 2006. Any person performing, conducting, directing or abetting a child marriage shall be punished with rigorous imprisonment up to 2 years and fine of 1 lakh rupees. Now clause 4. Clause 4 is basically related to the prohibited relationship. Prohibited relationship means section 5 clause 4 of the act prohibits solemnization of marriage of a person falling within the prohibited degree of relationship. If any marriage is solemnized under this, then the marriage would be void under section 11 of the act. Apart from this, violation of this clause would amount to simple imprisonment up to 1 month or a fine of ₹1,000 or both under section 18 clause B of the act. Section 3 of the Hindu Marriage Act, section 3 clause G of Hindu Marriage Act 1955 defined persons falling within the prohibited degree of relationship. Lenient ascents and affinity. If one is a lenient ascendant of the others, the relationship covers the Sapinda relationship, which extend up to the 5th degree in the line of father and 3rd degree in the line of the mother. By the affinity, affinity means, for example, father-in-law, daughter-in-law, mother-in-law or son-in-law. Now clause 5. Clause 5 talks about the Sapinda relationship. Sapinda relationship, section 5, clause 5 of the act. Marriage between the person having Sapinda relationship is prohibited unless there is a custom which allows them to do so. Sapinda relationship includes relationship by half or uterine blood as well as by full blood and by adoption. Any marriage solemnized under this would be void under section 11 of the act, and violation of this clause would amount to simple imprisonment up to 1 month or a fine of rupees 1000 or both under section 18 clause B of the act. Thank you.